All right, good morning. Welcome to the 294th District Court. My name is Chris Martin. I'm going to call this morning's criminal docket. If you can hear your name, please say present or here. Trey Gonzalez. Present. Bart Jones. Here. Mandy Jones. Brandon McClanahan. For the record, Mr. White filed waivers of arraignment. Pretrial has been set August 22nd. That's caused the first CR 23-109 and CR 23-110. Cody Wheeler. John McLeod. Marshall Flores. We'll recall that. Jonathan Keenan.
He's here, but he's outside waiting on his attorney.
Thank you, ma'am. Clinton Henry. Thomas Norman. Here. Braxton Henderson. Here. Thank you, Mr. Stott. Sean Davis. Here. Kristen Lopez. Kristen Nicole Ramirez Lopez. Hayden Mitchell. Is Mr. Mitchell, is that an NPR or SBA? You recall. If it's an NPR, he's going to be second in jail. He's on bail. Hayden Robert Mitchell. Jeremy Snelson. Mr. Sanders filed waivers of arraignment in both cases, CR 23-119 and 120. Pretrial has been set August 22nd. Donna Drake. Stacy Green. Kenneth Taylor. Mr. Schmidt filed a waiver of arraignment. Pretrial is set August 22nd, CR 22-195. Guido Dingemans. Thank you, Mr. Schultz. William Hayes. Here. Detriana Baker. China Bradley. Lisa Cabinet. Adam Chronister. Here. Wendy Price. Here. Simon Wiltz. Here. All right, is there anyone whose name I've not called? All right, Mr. Bingham, are you ready?
We're ready, Judge.
Clinton Henry, CR 23-107. All right, Mr. Henry is set for pretrial today.
Yes, Judge. We filed one. We're aware of the court's standing orders. The DA's office has certainly been great in providing us information. As we went through discovery, there was only 3 items, but I'll talk to Ms. Curry. I'm sure if she has them, she'll provide them. It was in the motion for discovery we filed. It was number 25, 26, and 27. It was any CPS records. Apparently, there's been CPS records involving Chloe and Alexandria Smith, who is the mother of the alleged victim. So we put that in the order, just wanting if they have them, the CPS records, or can get them for us. We wanted a NCIC, TCIC printout on Chloe Smith. The deputy referenced that he had been to this location many times prior, and we were hoping to get records of those visits to that location. I'm sure Ms. Curry will, or her office will provide those if they have them, but that was just 3 things we don't have that we think exist that we would like to have. Other than that, they provided discovery. The court standing orders covers everything else that we would have needed to file. We are going to file. We filed a motion to have the jury assess punishment in his application for probation. We're going to file before the jury comes in if it's a trial case. I'm hoping it's not. The other thing is apparently there's a new indictment warrant outstanding for him today, which we did not know about until today. And I asked Ms. Curry and she was not aware of it. So he'll be going into custody today. So I guess if that is a new indictment on new case, we'll add that to our discovery motion that we'd want to have that discovery in that case, which I'm sure they'd provide. We just don't know what that is involving. So
On the warrant, it's cause number CR 23122, assault causes bodily injury of a family member, $7,500 bill.
yeah, we're not aware of any other investigations. We just don't know what that would be, but it's there. So
Have you spoken with Ms. Curry or the state about these three specific items that you requested to see if they have a position on them?
I haven't judged. She's been great about getting us stuff. So I think in light of also the new warrant, we'll talk to her. We have talked many times about the case. These three specific things are relatively new ones that I saw in the discovery that I wanted. I'm sure they'll provide it if they have it.
My only concern is in past cases, we're dealing with records from the Department of Family and Protective Services. The DA's had a stance on that. So I want to make sure that we're clear going forward and we're on the same page. Mr. Bingham is asking for CPS records of certain individuals. And so I didn't want to give the state an opportunity to address that.
These are all individuals too involved in this case that had prior cases also involving those individuals. And I believe one with my client. That's why we're asking.
Let me do this. Let me recall the case.
Okay.
So give you time to address the warrant issue. Sure. So get with Ms. Curry. I just know that we've had numerous cases where we've dealt with CPS records. I think the DA's office has a procedure in which they follow. So I want to make sure that that's still the case. Give Ms. Curry an option to be heard on that. So let me have a seat, Mr. Henry, and just recall you. Okay. Yes, I should.
Thank you.
Thank you. Have any other counsel that's ready? Mr. Wells, you ready? William Hayes. This is cause number CR 23 300 through 306. All right, good morning, Mr. Wells. I show that we are set for our final docket call today. Any announcements?
Judge, we have been working with the state on a plea, and we would like to ask the court to set this for a plea on December 1st. We do have a waiver of jury trial here signed. I got to get Mr. Perry to sign it, but we've got it ready.
Okay, let me go ahead and see the waiver of jury trial. We'll have to get that and open the court on the record. We can say like her signature, but she'll need to sign it if you're going to waive there, right? Approach. Yes, sir. All right, Mr. Hayes, I'm gonna have you raise your right hand. I'm gonna administer an oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. Yes, sir. All right, thank you. Mr. Hayes, I have in my hand a document titled Waiver of Jury Trial. And what it indicates to me is that you and your attorney, Mr. Wells, have discussed your right to a trial by jury. That you're indicating that you understand that you have this right under the Constitution of the United States and Texas constitutions. You understand that you have the right to subpoena witnesses, confront and cross-examine them, and the state's witnesses all in front of a jury of your peers. You understand that that's absolutely right, that no one can take away from you. You understand that Mr. Wells cannot waive your right to a jury trial, either can the state or even the court. You understand? you and only you can waive your right to a jury trial. And it's something that, once it is waived, may not be restored to you. Meaning that if the court finds that you have entered into this intentionally, knowingly, and voluntarily, at a later time, if you decide that you don't want to enter into a plea agreement, you can't say, Judge, I want my right to jury trial restored. Understand? So once it's gone, for all intents and purposes, it will not be restored to you. And you've had your discussions with your attorney regarding your right to a jury trial. You're telling me today that, understanding that right, you wish to waive it and proceed in this case by a plea agreement. Is that correct? All right, then, the court will find that Mr. Hayes has been admonished as to his right to a jury trial, has waived the same intentionally, knowingly, and voluntarily. Furthermore, the court finds that Mr. Hayes is joined by counsel, Mr. Ron Wells, that this has been done in open court and on the record. The court finds that the state of Texas has also waived this right to a jury trial in this case, or hereby approves the waiver of jury trial. The court will set Mr. Hayes to enter his plea on December 1st, 2023, and I believe that'll be at 9 a.m. Is that correct?
That's correct, Judge, and of course, there is no plea agreement, second, ready for bench trial on that.
Okay, if there is no plea agreement reached in this case on December 1st, then the court will proceed with a bench trial. All right, so Mr. Hayes, remember, today is July, your next court setting is December 1st. You're still on conditions of pretrial release. You still have to check in, report, do all those things. Just because you're not coming back to court doesn't mean you don't have to do those things. You understand? All right, once you sign and get your notice of appearance, you're free to go. Mr. Elliston, correct?
Yes, correct, Your Honor.
That's what I thought. All right, Thomas Norman, CR 2364.
Yes, Your Honor.
Come on up, Mr. Norman. Mr. Norman. Just next time, you're fine, go ahead, but next time I want you to stay behind all of these individuals and go the other way, okay? All right, Mr. Norman said for pretrial, Mr. Ellison, have you received all of the online discovery?
I have, Your Honor, and we have reached a plea bargain agreement, and we just request a date for a plea.
And is there a specific time request? Are you doing anything to prepare for the plea?
No, sir.
Saving up money or having to go into custody or anything?
No.
Okay. Mr. Ellison, I could bring you back here in a couple of weeks on July 25th. Or the time after that would be August 22nd.
I think August 22nd would work better for me, I think, Your Honor.
Okay, all right. Mr. Norman, the court set you to enter your plea before the court on August 22nd. That'll be at 9 a.m. All right, so Mr. Norman, once you sign and get your notice of appearance, I need you to check in with my pretrial release officers. You're going to have conditions of pretrial release until you enter your plea in August. Okay. All right, so sign, do you have a notice of appearance, Mr. Ellison?
Yes, Your Honor.
All right, have him sign that, give Neil a copy, and then report over here to these officers and we'll give you more information.
Thank you, Your Honor. Will you be excused? Or may I be excused?
Yes, sir. Thank you, Chelsea. Mr. Estrada?
Your Honor, we have one on the docket, Braxton Henderson, CR 21-00289. It submit a waiver jury trial. Looks like it was accepted by the court on 6/27.
All right, I'll need to have that printed out and provided to the court so that we can go over that. So go ahead and have a seat. I'll call you back up.
Yes, Your Honor. do you want me to go to district clerk's office?
No, I'll ask my staff to bring it. Was it e-file or?
It was e-file.
It was e-file.
Yes, Judge.
Mr. Bean, are you ready?
Yes, Judge.
Who are you ready on?
Mr. Sean Davis.
Sean Ray Davis, CR 23-95. Mr. Davis is set for pretrial.
Yes, Judge. At this time, we've not received all the discovery. I've spoken to the investigator for sheriff's office, and he was unable to give me a timeline when that discovery would be available. But it is a forensic report that he is seeking to generate.
Is it a forensic report on a
Electronic, don't.
device? He didn't give you any kind of time frame.
No, Judge, he's fine.
Who are you working with?
Just working with investigator Colton.
August 10th, this year.
Judge, I have the jury trial is supposed to be in on Monday. It's been reset to August 7th.
About August 24th. It's evidentiary docket there. That's the next available, other than that, it'd be late September.
Yes, Judge, August 24th would work.
All right, we'll set this for status on discovery and pretrial. August 24th. That'll be at 9 AM. Once Mr. Davis signs, we can change.
Judge, in regards to the other two cases, my understanding, my last contact with Miss Lopez Ramirez, was she was in custody in Dallas County. I was unable to ascertain if she is still in custody. And then Mr. Mitchell, I was appointed last month, 22nd. And I've not had contact with him since that time. I believe at that point he was taken into custody. But I have not had the contact with him since.
If he was taken into custody, the board is in MTA, so he's already on bail. Okay. All right, we'll have his name called, once we get him back in custody. Where is that?
Yes, Judge. Any excuse?
Yes, sir. All right, Mr. Swirls, how are you this morning?
Very well, Your Honor. Thank you. I'm here on Guido Dingemans at CR 23-00085.
Mr. Dingus, come on up. Sure, we're set for pretrial today, Mr. Swirls.
Yes, Judge, we're set for pretrial. The only issue that we have identified is we have a notice of intent to raise the insanity defense. I haven't e-filed it. I have a hard copy. But we plan to offer evidence regarding insanity and are respectfully requesting an expert to determine the defense, Judge. May I approach?
Yes, please.
And the attorney to see copy.
All right, we're back on the record, Mr. Deegan's case. After speaking with counsel, the court is going to reset the pretrial on this matter to September 26th at 9 a.m. Court's going to take under advisement the defense's request for funds for defense expert for the defense of insanity. I'll report back to counsel between now and then, if there's further needs, of course.
Thank you, Your Honor.
All
Maybe
right, Mr. Deegan, don't forget that you still need to check in with your pretrial release officer and comply with all those conditions. Okay?
Thank you. Thank you, Judge. May we be excused, Your Honor?
Yes, sir. Thank you, Mr. Sorrell. You ready?
Yes, Your Honor. Stacy Green, CR 23-009-7.
Stacy Green, if you're on board. Show Ms. Green the set of pretrial.
That's correct, Your Honor. We've received discovery. We have no contested pretrial.
All right, then the court will set Ms. Green for a docket call. Which will be available on August 22nd.
That was the date I was going to ask for. Thank you, Judge.
All right, Ms. Green, we'll see you back on August 22nd. Sign your notice of appearance and you're free to go.
Drake, Your Honor.
Great. So cause number CR 23-48. There's a Donna Corey Drake on docket.
Judge, this is a first docket call. Ms. Curry and I have been meeting about this case, and we've got a couple issues that we're trying to work through prior to her making a formal plea recommendation. So we're both asking for an additional docket call. She's out in the hallway, but
All right, court will set Ms. Drake for the additional docket call on August 22nd at 9 a.m. Once she signs her notice of appearance, she's free to go.
that's
You're free to go.
my big shoes.
Yes, thank you.
Thank you, Judge.
Mr. White, are you ready on any of your minds? Yes. Who's Dr. Paul first?
Your Honor,
Yes. Patient condition. Once you've gone over those assignments. I think it's assignment. Yeah, I'm glad you're going over those. Before we call it yesterday.
Your Honor, can we call Mr. Wilkes?
Simon Wilkes, CR 23-82. Show Mr. Wilkes set for pretrial.
Yes, sir, we are. We'll abide by the court standing order. Ask the court to move this over to docket call.
You available on August 22nd?
I believe so, yes, sir. Double check that real quick, but, I think I'm already set up. Yes, sir, we're available.
All right, court sets Mr. Wilkes for docket call August 22nd, that'll be at 9 a.m. Mr. Wilkes, once you sign and get the yellow copy, you're free to go.
Thank you, sir.
Next one.
Your Honor, Deputy Honor Baker.
Speaker. It's cause number CR 23-44. Speaker is set for pretrial.
Yes, sir. We're gonna ask the court to set this, and I've talked with Mr. Hartwell a little bit about my issue on this. I'm gonna ask the court to set this over on a contested day.
Do we have a motion on file?
I believe we've either filed it this morning or we're in the process of filing it.
All right, court will set this for hearing on August 24th. Evidentiary docket. Victor, you're free to go.
Trent Gonzalez, Your Honor.
Grant Matthew Gonzalez, CR 22-135.
Your Honor, this is an unsuccessful PTI discharge. I would assume 24-hour evidentiary day. Can we just set it over on that? If we can't come to a resolution, we'll go ahead and do what we got to do that day.
All right, court will set Mr. Gonzalez for August 24th. That'll be at 9 a.m.
Ms. Cabinet.
Lisa Cabinet, CR 18-465 for pretrial. But Mr. White.
Your Honor, at the previous, at a previous court date, I had filed a motion for discovery. And, anyway, the state was trying to get something from DPS for me. I spoke with Miss Curry, late last week. She was still trying to get a hold of that, and she sent another, I believe she sent follow-up over to the trooper asking for the information. I would just ask if we could reset this to August 26th.
Is it a report or result?
Yes, sir. It was a report. As the court's aware, this is a fairly old case, and so there were some things I'm thinking there's probably a glitch in the proverbial system somewhere. But yes, sir, it's reported. It's a major accident report that it wasn't forwarded over
And Ms. Curry's gonna look into that. I believe Mr. Woodwhack was going to, but obviously Mr. Woodwhack's not with us anymore.
All right, let's reset to August 22nd. Pretrial,
Your Honor, may I approach?
yes.
Briefly.
Ready to go, yes.
Your Honor, I've got, I need to go over to Chronister, and I've got a couple of other cases I'm gonna ask you to recall over when I come back.
Yes, sir. Okay. That's great. I know you're running here and there. It's way. John McLeod, CR 22-334. All right, sure that we're set for the status on the EFPS record.
Don't have it yet. I'm unaware, I don't, as.
What's the?
This is John McLeod, CR 22-334. Assault on a child. There was a request for EFPS records.
Clause number again, Judge, on that.
CR 22-00334.
Your Honor, I show that we received those on June 29th. And we will make those available to the court for camera review. Have that done by tomorrow, if not today, Your Honor.
Okay, then the court will reset. Do you know how many records that consists of?
It's a it's a USB, Judge, that it took us that we had to break into 10 different files to upload, so I expect it's kind of lengthy.
Mr. Adams, I'm gonna reset this for status on the camper review, or are you available August 22nd?
We're available, Your Honor.
All right, so I'm not sure I'll have that completed by that time, depending on when I get them. How voluminous they are, but either way, it's come back on the 22nd. I can give you an update on that.
Yes, sir. 9 o'clock, I guess. Or in my case, 9.
Yes, sir. All right, so Mr. McLeod, we'll see you back on August 22nd. Once you sign, get the notice. Parents should be gone.
Yes, sir. I think that's all I have on your documents.
Yes, sir, that's all that I showed. Have anything separate?
Don't think so.
I can give you some stuff if you want some stuff.
Well, I'm helping Mr. Strada out this afternoon.
He won't lie. Thank you, Mr. Adams. Good to see you. Curry, Mr. Bean, are y'all ready? Yes, sir. All right, Mr. Henry. All right, back on the record, CR 23-107, State versus Clint Ryan Henry. And I recall this case, to give the DA's office time to discuss with the defense the requested items for discovery, request for some DFPS records, NCIC, TCIC record. What was the third item you were wanting?
Third was just previous records from that location, the addresses and discovery. The 3 items I was concerned about, I've talked to Ms. Curry, we're going to get those. I think the CPS records, they're going to subpoena, we have no objection to in-camera, an in-camera review. So I think the discovery issues, the DA's office thing always is great about working with us on that. And they are in this case as well.
Okay. Yeah, well, what we can do is we can set in September for additional pretrial, allow the state to subpoena the records, and then if it comes in prior to our next hearing, they can go ahead and be submitted in camera. Has the state received any information from Mr. Bingham regarding narrowing the scope of the record search?
I can do that. I'll talk to you about the CPS.
The CPS process, Judge, I think it's easier if we just make his broad request rather than have somebody let us know, go through and tell us whether or not there is anything. I would be more comfortable with requesting anything related to the list of persons he's given to me, that he's identified, and then doing the in-camera inspection.
Okay, and then what assistant court is doing the camera inspection is some kind of parameters that you're wanting the court to look for, so I can know whether or not that those are mitigating or exculpatory. So obviously names of individuals, dates, things that the court wouldn't otherwise know. So if I can get those parameters given to me at the same time I receive it, that would go a long way.
Absolutely, do that.
All right, so if you get your calendar,
September 12th or the 19th. The 19th is the best one.
all right, let's do that then.
September 19th.
Yes, we'll do September 19th for pretrial. And status on DFPS records.
Thank you, Judge.
All right, so Mr. Henry's gonna be taken into custody at this time.
Oh, Safely. Apparently, there was a request for after in this case. It's not necessary as action. On this charge, and I will provide the TRA to. Websites. Associated with TRA.
So he has been arrested on the assault and the violence.
Yes, sir. And I have the TRA.
Okay. All right, then, court will grant the state's motion to draw the warrant. Mr. Henry, understand that that's a process. It takes time, and paperwork, long, but here, sending the warrant, draw to the places. So as you leave here, the system's gonna still show active warrant for your arrest. If you get pulled over or ride a McDonald's or something, you know, going to jail, and on that out there. So be careful and cautious, all right? I will see you back on 19.
Thank you, Judge.
All right, we're back on the record, call number CR 21-00289, state of Texas versus Braxton, Robert Anderson. And I understand that there is a waiver of jury trial that the defendant is applicable for technical correction shot up.
That is accurate, Your Honor.
And is Mr. Henderson intending to proceed by plea or non-jury trial? Bench trial is not one of those options.
Judge, and we left it unchecked because this may be a plea. In the event there's not a plea, this would be a bench trial.
That's correct, Your Honor. The only agreement that the parties have at this time is that, we will proceed on the lesser included offense manslaughter. Whether it ultimately is resolved by plea or bench trial has not been determined yet. We would ask that the setting be after the court's trial setting in August.
After the what sake?
The jury trial setting that the court has in August.
All right, Mr. Henderson, raise your right hand. I'm going to issue an oath. You certainly swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth. So help you God. Yes, sir. All right, how are you? Mr. Henderson, I show that you are represented by Mr. Edward Estrada. As your attorney, has he discussed with you your right to a waiver of jury trial? And in discussing the waiver, you understand that you have the absolute right guaranteed to you under the constitutions of both the United States and the state of Texas to have your case tried before a jury of your peers. You understand that? Yes, sir. And during that trial, you have the right to cross-examine and confront the state's witnesses and evidence in front of that jury. You understand that? You also have the right to subpoena your own witnesses and examine them before a jury. You understand that? You understand that no one can take your right of jury trial away from you. Mr. Estrada, the court, the state, no one other than you. You understand that? And if you waive your right to jury trial, you understand that it may not be restored to you. Meaning that if you later change your mind after today, let's say that you're hoping for a plea agreement and the plea agreement doesn't work out, you have to go to trial. You can't say, well, now, Judge, I want a jury trial. You understand that once you waive it, as long as you're doing so intentionally, knowingly, voluntarily, not under arrest or coercion, then that right will not be restored to you. You understand that? Yes, sir. Understanding all of those things, you wish to waive your right to jury trial. Mr. Estrada, you join with your client in that waiver?
We do join, Your Honor.
All right, Ms. Curry, I find by your signature, you're waiving your right as attorney for the state to a jury trial. Is that correct?
Yes, Judge.
Court finds that Mr. Braxton Henderson has been admonished as to his right to a jury trial and a waiver thereof. The court finds that he has with counsel intentionally, knowingly, and voluntarily waived his right to a jury trial, what proves that waiver? Or will said, Mr. Henderson. This case results in a bench trial. How long would the defense state anticipate it will take?
Three to 4 days, Your Honor.
That's correct, Your Honor. 3 to 4 days. I discussed the date, the trial dates with all our, we would have the same experts to be present that have already been designated.
All right. Court sets Mr. Henderson for plea on Tuesday, September 26th. If there's no plea agreement on that date, then the board will in its bench trial on this matter on Wednesday, November 15th. Beginning at 9 a.m. Once Mr. Henderson signs, it's ready.
Yes, sir.
Right, who's ready? Josh, are you good? Who you ready on first? If you have anyone you're ready on, that's, if you don't need Ms. Kirk.
Your Honor, I believe they're both motions to continue, which I haven't been part of those conversations.
My understanding is.
Yeah, go ahead. Go ahead. Go ahead. I probably gotta move on to Mr. Wild. Yes, Mr. Wild, are you ready? Yes, sir. You ready on Adam Cronster?
Yes, sir, I am.
All right, Mr. Cronster. Says file number CR 23-26, the state of Texas versus Adam Michael Cronster. On the charge of evading arrest or detention of the vehicle. See that there's a proposed plea agreement, Mr. Cronster, if you'll raise your right hand. Place you on oath, sir, do you swear that the testimony you give to the court be the truth, the whole truth, and nothing but the truth, so help you right? And you can lower your hand, speak up loudly and clearly during your testimony. Mr. Cronster, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
You're represented by your attorney, Mr. Nolan White. Are you pleased with Mr. White has done for you?
One more time, sir.
Are you pleased with Mr. White and the work that he has done for you?
Yes, sir.
Is there anything about the paperwork that you've read over and signed today that you do not understand? Mr. White, do you believe Mr. Cronster is competent to enter into this plea that he's doing so intelligently, knowingly, voluntarily? Can you explain to him the advantages and disadvantages of patiently?
Yes, sir, I believe that Mr. Cronister is mentally competent, that he understands the procedure and he gets him here today. I believe that he entered into the plea freely, knowingly, voluntarily. And I have explained to him the advantages and disadvantages of a deferred adjudication.
Thank you, Mr. White. Mr. Cronster, you are charged by indictment with a third-degree felony offense of evading arrest or detention with a vehicle that does carry a range of punishment. If you were to be convicted and sentenced, that would have to be somewhere within the range of the minimum 2 years to the maximum 10 years in prison, and a fine not to exceed $10,000 if imposed. I see the plea agreement is that you, in exchange for your plea of guilt to that crime, state's recommending to the court that the court defer a finding of guilt today. It means that the court consider the evidence, but if the court finds it sufficient, that the court not convict you, but follow their recommendation of placing you on community supervision for 2 years, assessing a $1,000 fine plus court costs, reimbursement fees, and dismissing a reckless driving case And as far as special conditions of community supervision, that you are to take counseling and follow its recommendations. Is that your understanding of the plea agreement?
Yes, sir.
And that's what you're asking for to approve today?
Yes, sir.
Now, Mr. Cronster, before we go any further, do you understand that a deferred adjudication plea, if you violate any of the terms of your community supervision, you've read over and signed those today, so you know what they say, correct?
Yes, sir.
If you violate any of those, the state can file a motion to adjudicate your guilt, please convict you. The state would ask the court to do a number of things, including revoking your community supervision, convicting you, and sentencing you anywhere within that range of punishment, from the minimum 2 to the maximum of 10 years in prison. You understand that?
Yes, sir.
Understanding all that, you still wish to go forward?
Yes, sir.
All right, Mr. Cronster, how do you plead to evading arrest or detention with the vehicle?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened or forced you to plead guilty?
No, sir.
Board accepts the defendant's plea of guilt. Mr. White, any objection to the stipulation of evidence?
No objection.
That is admitted, and the board takes judicial notice of the defendant's judicial confession. Anything further from the state,
No, Your Honor.
from the defense?
No, sir.
All right, the court has reviewed the evidence. The court finds that there is sufficient evidence to convict Mr. Cronster of this offense. The court will follow the plea agreement today. Or hereby defers the finding of guilt for evading arrest for detention of the vehicle, a third-degree felony. The court places Mr. Cronster on 2 years community supervision, orders him to pay a $1,000 fine, $290 court cost, $35 in reimbursement fees. Court dismisses under section 1245 DA 2022-1281 reckless driving. Mr. Cronster, you hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I have you come forward to be fingerprinted with Deputy Martinez. Is
Yes, sir. I've got, Ms. Price.
Wendy Price, CR 22339.
Your Honor, we're set for docket call. We're gonna, and I believe Mr. We're gonna ask the court to set this for plea on August 27th.
All right, court says Ms. Price was plea on August 22nd. Gonna be set at 9 AM. Please,
Yes, sir.
at 9 AM.
And, Ms. Bradley.
China Bradley, CR 20-1.
Your Honor, we've already been set on the contested docket for the 25th. I would note to the court that we're really close on this one. I don't know that, I don't anticipate that actually being a hearing, but there's some issues that we're trying to work through on it to get it worked out. If we can't get it worked out, we'll certainly be ready that day.
Do we set it today for any reason, was there a status?
You just wanted the status of what we were, yes.
Okay. Okay, all right, so Ms. Bradley, we'll see you back on the 25th.
Mr. Taylor has.
So, yes.
Ready on Mr. Flores, Your Honor. If it's all right, Judge, I'm gonna ask that he remain right here by the door.
Sure, that's fine.
Thank
All
you.
right, this is cause number CR 21-165, CR 22-18, State versus Marshall, Florida. I believe this is on your motion for continuance. Go ahead, Mr. Russell.
Judge, I had filed a motion to continue because of a prior trial setting that confounded this current trial setting. The state initially opposed. Now, as I understand, no longer opposed. That conflict resolved. The state and I have also entered an agreement. Ms. Curry.
On the record, I'll turn it. All right, board finds that the state from the oral motion for dismissal in file number CR 21-165, CR 22-18, State versus Marshall, Florida. The board grants that motion. And the board will sign an order once it's submitted by the state. Mr. Flores, you're free to go.
Mr. Keenan was here, I'm gonna ask the court permission to step outside.
Yes, sir. Mr. Wheeler. Same as the All right, Mr. Wheeler, let's see. At the last court setting, we did a 3-day buyback. I had a couple of things for you to do. You did all of them. You paid your probation, you paid your restitution, you did your 20 hours of service. I want to continue on that same track until we get you caught back up. Once we get you caught back up and you're taking care of your business, then I'll let you on the sanctions board, but we need to continue on the same track, okay? If there are any issues I need to be aware of as to why we can't do the same thing. No, okay. All right, so we'll do the same thing, 3 days in jail, for non-compliance of the following. 20 hours community service. $435 to restitution, $65 to probation. So let's say again, your work, remind me, did you say that you were working out of town, so that you got a new job and now you're back? You said it's not, it doesn't matter, it's is there a day that's better for you though, between a Tuesday and Thursday? Right, I'm bringing back on August 22nd. CR 1797. Let's see, at our last sanctions court hearing. You were sanctioned and served 3 days in jail for your admission of smoking marijuana. I see that you did serve your 3 days in jail. You complied with your substance use evaluation. You complied by paying your probation fee, court collection fee, and you complied by doing your community service. So that's a job well done. Where'd you do your community service at?
In Edgewood,
Heritage Park? What'd you do over there?
cleaned out buildings.
Is that where you're gonna do all of your community service?
I like it.
All right, so what I'm gonna do is same thing I did for Mr. Wheeler. I'm gonna reschedule you to August 22nd. And I need same things except the jail time. Okay. I need 65 to probation.
I'm sorry,
Probably should have led with
I was gonna cry.
probably should have led with that. $65 for probation, $55 for court, and 10 hours of community service. But I am gonna UA you today.
Okay.
I'm not gonna have any bad results, am I? No?
No, sir.
Let me write this up for you. Same thing that I told the other gentleman. Once you get to where you are doing this on your own, I'll let you out of sanctions court. Once I see you can do this every month and we get you back on track, which is the purpose of sanctions court, then I will keep you out of court and I'll let you just meet the probation officer and do it on your own time, okay? So there's really an incentive here for you. All right, Mr. Chairman, come on forward, sign this over here. We try probation, see if they have anything else for you and do that. Oh, actually, still on time. Bart Jones. It says CR 23-108. Believe that you were set last time for arraignment and I gave you additional days time to hire an attorney. Have you done so?
Yes, sir. I'm currently going through a divorce also, so I just spent a substantial amount of money for my I'm a divorce attorney also. If I could just get a little bit more time, 'cause I just lost my job also. I have another job on the line. If I could just get a little more time to get the other attorney paid in full, I would appreciate it.
If you hired an attorney, talked to an attorney.
Weiner,
And when were you going through the divorce prior to being indicted on this cause?
yes, sir. This is all tied together, actually. It's this come from part of the divorce happenings. Yes, sir.
Have you talked to the other attorney besides Mr. White?
I actually hired Zach Elliott for my civil part of it, and I discussed with him
Did you hire Mr.
2 weeks ago.
When?
2 weeks ago. I had Matt Hawkins for my divorce and just wasn't accomplishing what I needed to accomplish. So I had to get another attorney, so it's two attorneys I've paid now.
A little concerned that you're hiring family law attorneys before you're hiring a criminal attorney. There's only one of those attorneys that can keep you out of jail. Do you know that?
Yes, sir, I understand that, but there's, it's all, like I said, it's all kind of tied together. So I understand that the criminal side is not the civil side, but there's some factors in the divorce that will be factored into the criminal side as well.
I understand that can be related, but also understand this, never looks good to the family law court judge when the husband or dad walks in the jumpsuit. Handcuffs.
I understand.
So if you put off a criminal case, that's what's gonna happen. You paid money to post a bill, paid money to hire a civil lawyer. You're not spending your money to hire a criminal lawyer. And only, in my opinion, the criminal lawyers are gonna be the one to keep you out of jail and put you in the best position to be successful in the family law case and keep you out on bail, keep you at your job, take care of all your obligations. A lot of people think that they're just gonna put the criminal lawyer on the back burner, take care of all their other business.
If you'd like to appoint me one today, I'll take it. And if I decide I want to hire, then we can go that route. I'm not trying to be difficult. I'm just,
I know you're not.
yes, sir.
I'm just trying to give you some advice.
Yes, sir.
I'm gonna give you some more time. Okay, but if you come back without a lawyer, I'm gonna have to take all these other things into consideration. Understand?
Just go ahead and appoint me one then, just in case the job doesn't go through.
And it doesn't work that way. It's
Okay.
not- You get appointed if you're indigent.
Okay.
Or you can't appoint, but you're working, you've already hired a lawyer, and you post a bill. So
Right.
I can already tell you, you're not gonna meet the indigency requirements.
Yes, sir.
Because taxpayers pay that. So I'm gonna reset you, I'm gonna give you some time. This will be the last time. Okay,
Yes, sir.
August 22nd, I expect you to come back with a lawyer, I don't care who that lawyer is. I wouldn't put all your eggs in one basket, you go around and find someone. Mr. Weiner's not available or you can't afford him, you need to make other calls,
Yes, sir.
all right? So August 22nd. At 9 AM.
Sir.
All right, Kate Mitchell, come on up, CR 21-403, CR 21-406. I believe this is first hearing on motion to revoke with counsel, Mr. Grant, is that correct?
Yes, Judge. Judge, I'd like to apologize for my client. There was some misunderstanding when I told him at our last reset that I was gonna be in trial this week. He assumed that meant his case had been reset, and he was unaware that he was supposed to be here today. So he was able to get here today. We have not received all the discovery for this motion. There's a new offense alleged. We haven't received information on, so we requested that be reset.
All right, court will set this for the contested docket on August 24th. It'll be at 9 AM. As long as Mitchell is on bill. Mr. Mitchell, you understand you're still on probation. Yes, sir. So for everything that you miss, you test positive, all of those things are gonna end up in their motion, they're gonna amend it. So I've got notes here that you miss, delinquent, all those good things, talk to Mr. Manning, but understand that you're still on community supervision. Okay. All right, we'll see you back on August 24th. Thank you, Mr. Manning, for coming back. Never get any confirmation on Mr. Lopez. We get what it's for.
And when I looked it up, Judge, she was not in Dallas County. That's the last contact I had with her when she was in Dallas County.
All right, we'll have her.
That's that, just Brown.
Mr. Ashmore?
Yes,
Do you have anything else?
Judge, that's all I have. I guess so if that does show up, we can just have her call back to the 1:30 docket.
I'll tell you what, I'll make sure she's done. Mr. Ashmore, did you find, Keenan?
No, Judge, I haven't been able to find Mr. Keenan. I can call him twice, texted him, zero, not ever here. I'm gonna stick around because my state and I are working on an enhanced resolution for seven, it's not gonna be years. That's the one. Okay, and so my request is it's like we makes it back. You be instructed to report to the jail one way or another. So that instruction will be forthcoming again, and I'll be at the jail. Loading back with paperwork, we to try to resolve Mr. Peters' case today, which will be jail pressure, and some trial pressure, and eliminate the need for any further hearings.
Was Mr. Keenan advised that we were going to be conducting a UA today? Okay. Do you want to go ahead and argue your motion for continuance, whether he's in custody or not? We probably still need to talk about that.
Yes, Judge. So if I may, I had.
Yes, this is CR 22-00029 State versus Jonathan James Keenan. Court's gonna entertain Mr. Ashford's motion for continuance. Court will note that Mr. Keenan is not present in the courtroom. He was present earlier, however, he is not at my knowledge at this point. But the court's gonna go ahead and take up the motion for continuance outside of his presence.
Judge, I had, well, one, I apologize for having to file this. We had a trial setting on a case that ultimately didn't go in May that confounded these trial settings, and I was compelled to file yet another motion to continue because we have a family reunion planned with my extended family in Crystal Beach, Texas. We've paid for the Airbnb and our half of the grocery bill, blah, blah, blah. And so my request is to be able to continue this case. I understand we are not number one. We are in the top 5. We still have a chance of being reached. However, I'm humbly asking the court to go to the family reunion and have Mr. Keenan's case reset, even if it's the first immediate week for jury trial after the current July 31st setting.
State.
Judge, especially said number 1 case that the court knows entered a waiver this morning. We are ready on the case right behind that. I see no reason that the case, wouldn't go. So with that, we're going to go.
Keenan's motion for continuance. We saw on July 1st, or we said no. That one will start on next trial, which will be August. Deputy Martinez, you can start that step in the hallway and call the name John James. Certain filings 3 times, but I think that this matter.
document. Next. For you to pass the case, I think it's important to read the record. Mr. Keaton has my business cell phone. We communicate through text and a phone call. Text me. I'm sure I was coming this morning. I had been diverted like a lot of people coming from Ontario because of the construction at 6420 came along right around. About 9 after. Visited with him, visited with Mr. Waddell. At some point he left. I have texted him twice and called him twice to get back up here. I don't know. He was smoking, standing outside, what have you. No response to those.
Thank you, Mr. Ashmore. All right, then the court has ordered Mr. Keenan to appear today. Mr. Keenan did appear at 9 a.m. However, his case was not called, he was not given permission to leave the court. The court has free fall of this case. Mr. Keenan is not present. His name has been called loudly 3 times. The courthouse, no response. The court hereby finds that his bail is insufficient. Court's issuing a warrant of arrest. Mr. Ashmore, you have Mr. Peters. Do you have anyone else this afternoon?
I do not have anyone else this afternoon. Mr. Peter really was supposed to be on dying. Because he is trial set, he's not in the top 10, but Ms. Curry and I are 2.
I don't see it. Oh, I see. He's not on the document. You're just saying we're sticking around and talk about.
To resolve, he was in the top 10, not top 5. Stay where. So we didn't file a motion to continue with this case. And I don't think he's separating out of document status, he's just waiting jury trial.
Okay,
But she reviewed the file, pretty good. We have a recess. Work something out, hopefully, it's business included. Yeah.
well, he's not on my docket though, that's what I'm telling you.
Oh,
No, I did, when Mr. Ashmore brought it to my attention that we might be able to resolve that, I asked Ms. Taberham if he could be added. I think she's in the process of doing that.
Oh. All right, very well. Yes, sir. Yes, sir. Mr. Keenan showed back up.
I'll have him report to courtroom or to the car.
Yeah, you have it report up here. I'll take care of it. Right, I believe that concludes the criminal docket. The morning session. So we'll stand in recess until 1:30. Oh, yeah, you know what, we go. Kristen Lopez, you go, but yeah, go ahead, call her name as well.
Yes.
We're gonna have Kristen, Nicole, Ramirez, Lopez's name, all loudly distinct 3 times. If there is no response, we'll put you, gentlemen, sign.